Hey everybody, and welcome to the next installment of Better Call Big, where today I'm going to talk about surveys. One of the most common clauses that is put into an agreement of purchase and sale is a survey clause. Now, a lot of the times you'll ask the vendor, the seller, that do you have a survey as a salesperson, and the vendor will say, yeah, I have a survey. Or sometimes they'll say no, in which case you scratch out the clause. Now, the problem is that sometimes the survey that the vendor thinks that they have and what you promise on the agreement of purchase and sale are two different things. What I mean by that is that if you were to write that, the vendor agrees to give whatever surveys in their possession or any existing surveys, that's one thing. But if you say that the vendor is willing to give an existing survey showing encroachments and boundary lines, fences, things like that, you may find that the survey that they have is not actually that detailed, in which case the other lawyer, the purchaser's lawyer, will see the survey and say, well, this isn't the survey you promised me, you are now in breach. And sadly, when you're in breach, one of the most common remedies for a situation like that is the vendor will end up having to pay the purchaser's title insurance fee, which could be anywhere from $400 to $2,000, depending on the value of the property. So essentially, the moral of the story is, first of all, make sure that you have a survey. Second of all, as a salesperson, look at what survey you have and make sure you're not over-promising what is actually represented on that survey. So hopefully you find that helpful, and till our next episode of Better Call Big.